All right, can everybody hear me okay?
Yes.
Yes, Your Honor. Good morning.
Good morning. Okay, Ms. Boulay, are you ready to go?
Good morning. I am ready.
Good morning and thank you. And Ms. Crane, are you ready to go?
I'm ready, thank you.
Okay, we are on the record in the Colorado Public Utilities Commission's proceeding number 25F-0270CP. My name is Connor Farley. I am the administrative law judge assigned to this proceeding, and it is approximately 9 a.m. on November 18th, 2025. And this evidentiary hearing is being webcast. This hearing was scheduled in decision number R25-0625-I that issued on August 28th, 2025. The hearing was scheduled as a remote hearing in which the participants are participating from discrete locations. Decision number R25-0765-I that issued on October 24th, 2025 included instructions for participating in this remote hearing by computer or telephone. I'll take appearances, and I'll start with the complainant.
Thank you, Your Honor. My name is Lysenko, and I'm the complainant.
Great, thank you and welcome. I'll turn next to the respondent.
Good morning, Your Honor. Attorney Sean Jennings on behalf of the respondent On Location Events, LLC.
Thank you and welcome. And I see that Mr. Valentine is here, presumably on behalf of a couple of subpoena parties. Mr. Valentine, why don't you go ahead and introduce yourself and let us know who you're representing.
Thank you, Your Honor, and good morning. I'm Mark Valentine from the law firm of Keys and Fox on behalf of Ace Express and Ramblin' Express.
Okay, thank you and welcome. And I'm well aware that we still have your outstanding motion to quash, Mr. Valentine, which I plan on addressing before we get into the substance of the hearing. So I apologize that I was not able to address that motion and the outstanding motion to limit the scope of the hearing. I was on vacation for over a week and got back yesterday, and the responses came in right before I left for vacation. So in any event, they're going to be addressed this morning first thing. Why don't we just turn to both of the outstanding motions, unless there's anything that any parties or Mr. Valentine you'd like me to address before we move to the outstanding motions. I'll pause for a moment, let anybody interject. Okay, all right. So let me turn next then to the two outstanding motions. And the one I plan to start with is the motion to limit the scope of the hearing. And that motion was filed by you, Mr. Jennings. Do I have that right?
Correct, Your Honor.
Okay. So, and as I understand it, I'm just going to read from your motion, just to get on the record my understanding of what you're asking for, Mr. Jennings. It's your contention that the complaint, and now I'm reading, quote, covers a period of 20 days from May 29th, which was the issuance of decision number R25-0406, to June 18th, when Mr. Lysenko filed his new complaint. That's quoting the motion to limit at page 2. And more specifically, I think the motion is based on the contention that the complaint alleges violations, or that the respondent has not complied with decision number R25-0406, which was issued by Chief Administrative Law Judge Adams on May 29th, 2025 in the previous proceeding. I don't have the proceeding number in front of me right now, but that's what the complaint is all about. And Mr. Jennings, I think you're essentially arguing that based on your review of the witness list and the exhibits that were disclosed, that it appears that Mr. Lysenko intends to present evidence relevant to a much broader scope than what I've just recited, which I think is your contention about the focus of the complaint. Do I have that right, Mr. Jennings?
Yes, Your Honor.
Okay. And what you're asking for, Mr. Jennings, as I understand it, is an order from me limiting the scope of the hearing to what I've just described, which is that 20-day period, and whether your client has violated or not complied with the decision by Chief ALJ Adams. And you want to further exclude testimony and evidence that goes beyond that scope, that does not relate to the advertising by your client on its website. And you also want to exclude any evidence that, I think this is the quote, is substantially identical, duplicative, or cumulative to the record and proceeding number 25F-0270CP, which that's the proceeding number or the number of the proceeding that Chief ALJ Adams presided over, which ended with decision number R25-0406. Do I have everything right so far, Mr. Jennings?
Yes, Your Honor.
Okay, and the other piece of relief that you're asking for is judicial notice of basically the whole record in Chief ALJ Adams' previous proceeding number 24F-0236CP. And I gather that you're asking for that, at least in part, Mr. Jennings, as a way to support your motion and render unnecessary the admission of any evidence that's duplicative of what's already in the record in that previous proceeding. Do I have that right?
That is correct, Your Honor.
Okay. Is there anything else that you'd like to say in support of this motion, Mr. Jennings? I'm just trying to cut to the chase here.
Sure. Thank you, Your Honor. That is all correct. And we tried to lay out the background because Mr. Lysenko, Mr. Valentine, 4 parties participated in a heavily litigated proceeding. Judge Adams issued 3 substantive recommended decisions in that case. And those decisions set forth findings of fact and conclusions that I don't believe there's any dispute about, for example, the findings of fact in those prior cases. The final decision issued by Chief Judge Adams became the decision of the commission. And so what we were asking for in the motion, and just looking down at the bottom of page 6, is to limit and narrow the scope of today's hearing to whether On Location violated the May 2025 decision from Judge Adams, which entirely pertained to advertising. And so it's our contention that Mr. Lysenko apparently is going to try to present evidence and raise issues that go well beyond that scope. Thank you.
Thank you, Mr. Jennings. So, Mr. Lysenko, I'll take a shot at characterizing your response. And then, like with Mr. Jennings, I'll give you an opportunity to correct anything that I get wrong or add to anything that I'm about to say. So as I understand your response, Mr. Lysenko, number one, you're saying that the evidence in this proceeding should not be limited to the 20-day window identified in the motion, which is the 20 days in between the entry of the recommended decision by Chief ALJ Adams and when you filed the complaint in this proceeding. And as support for that, you contend that the complaint alleges, and I'm quoting here from the response, ongoing and subsequent violations, including continued advertising and ticket sales in violation of commission rules. That's end quote there, and that's your response at page 5. You also state that the evidence should not be limited here based on the following statement, and I'm quoting again, if On Location's relationships with Ace Express or Ramblin' Express or the nature of its operations have changed since the prior decision, such evidence is essential to a full and fair adjudication. And that's your response at pages 5 to 6. And then on page 7 of your response, you state that evidence regarding these partnerships is essential to assess whether On Location has found ways to circumvent the order or continues to engage in prohibited conduct and is therefore directly relevant to the issues in this proceeding, end quote. And that's your response to page 7. And there, the partnerships I believe you were referring to, Mr. Lysenko, were between On Location and Ace Express and Ramblin' Express. Okay, thank you for that. And then the order that was referenced in that sentence is, again, ALJ Adams' recommended decision in the previous proceeding. Do I have that right, Mr. Lysenko?
Yes, that is correct. And I pointed in my response, I pointed that Chief Administrative Law Judge in his order mentioned that location is supposed to cease and desist until it comply with all Colorado PUC regulations. It did not only point the advertisement. There is the all word. And that all is kind of goes beyond that 20-day period. And how is the 20-day period, how we can limit that? First of all, after complainant already filed witness and exhibit list, and now we're gonna limit it, and the complainant not gonna get a chance to supplement the witness and exhibit list. And secondary, it's an ongoing violation. How we can just limit ongoing violation just to 20 days if it's if there are evidence, and how we can apply rules only to certain time of period, not to the whole violation. That was my response about.
Okay, thank you, Mr. Lysenko. And so I'll just tell you, Mr. Lysenko, that I've read virtually everything in the previous proceeding, and obviously I read the recommended decision by Chief ALJ Adams, and I agree with you about what Chief ALJ Adams stated in the ordering paragraphs. In other words, he didn't just say that On Location needed to cease and desist from the types of advertisements that were identified in the recommended decision. He also said that they needed to cease and desist from basically violating any rules or statutes. But I must tell you, I mean, I interpreted that as Chief ALJ Adams just basically paraphrasing the second of the two rules, commission rules, that he had identified as having been violated by On Location. But my interpretation of the recommended decision is that he focused exclusively on the advertisement on the website of On Location. In other words, he really didn't find anything else any other violations, or that he didn't find that the basis for the violations that he found was anything other than the advertisements on the website. So I think my interpretation of the recommended decision is that that's what he focused exclusively on in finding violations and concluding that they, violated the cited rules in the recommended decision. Do you disagree with me on that?
I wasn't prepared to answer that question. I would need to kind of detail and go into that, because I probably do have some responses and some arguments, just going line by line, because there were some points where administrative law judge was going just a little beyond just advertisement and kind of into the operations. Chief administrative law judge made a great favor, kind of avoiding some sharp corners for on location and not assigning penalties. So, so let's say that I'm not prepared to answer that question. I will need to kind of go line by line with that, whether, because I was under impression that there were some of the arguments about operations itself, not just advertising.
And yeah, I think there were definitely arguments about conduct other than advertisements on location's website. But I just cite for you in that decision number R25-0406, there's a statement by Chief ALJ Adams on page 26 of paragraph 119. The offense here is the advertisement appearing on location's website at the time the complaint was filed. So, that's obviously pretty far into the recommended decision at page 26 of paragraph 119. But I think that's basically what became the focus of Chief ALJ Adams' decision at that point, after wading through an awful lot of allegations regarding things not just limited to that advertisement. But let me ask you this, Mr. Lysenko. Can you tell me, give me just a moment. Can you tell me where in the complaint in this proceeding did you allege that On Location has attempted to circumvent Chief Judge Adams' recommended decision by changing its relationships with Ace Express and Ramblin' Express? Maybe you have access to your complaint. Do you remember whether you included that allegation in your complaint?
I did not include that allegation.
Okay.
Whether they changed it or not, I did not include that.
Okay. So, I've characterized your response. If I've done so inaccurately in any way, please let me know now. And then also, if there is anything else you'd like to say in response to the motion to limit, and in particular supporting your argument that it should be denied, please let me know at this point.
So again, number one, like I mentioned before, first of all, it's going to be the complainant will be prejudiced, because the motion was filed after complainant already filed the witness and exhibit list. So if we're going to limit just to that 20-day period, that gonna leave the complaint without the exhibits. And again, the ongoing violation, the PUC statutes and the maximum fine rules, they state that each day of violation is the new violation. And they go far beyond the 20-day period. This is the ongoing violation. And to apply decisions without the applying penalties, as we can see, don't work. And to apply properly the penalties, they have to be, the PUC cannot lock up the violation just to 20 days period. And the rest of the violation will be just left without the proper attention. This is the only reasons and the only response I have on that. Thank you, Your Honor.
Thank you, Mr. Lysenko. Okay, well, here's what I'm going to do on this, on the motion to limit. I'm going to grant it in part and deny it in part. So I agree with on location that Chief ALJ Adams' recommended decision found and concluded that it was the advertisement on location's website that was the basis for the violations found in Chief ALJ Adams' recommended decision. So the evidence today should be limited to that particular issue, whether on location failed to comply with Chief ALJ Adams' decision and recommended decision in that recommended decision. I think it's R25-0406, and in particular directing on location to cease and desist from violating the rules cited in the recommended decision as they pertain to on location's advertisement on its website, and in particular its failure at the time to disclose, adequately disclose in any event, that it was merely a transportation broker and did not itself provide the transportation services advertised on its website. So I agree that the focus of today should be limited to that narrow question. I disagree with the contention by on location that necessarily means that this proceeding should be focused exclusively on the 20-day window between the entry of the recommended decision by Chief ALJ Adams and the filing of the complaint in this proceeding. I believe that Mr. Lysenko should be permitted to go beyond the 20 days. I don't think that there should be any evidence that about actions that took place before the entry of the recommended decision by Chief ALJ Adams. So I agree that we shouldn't have any evidence that predates that, but that Mr. Lysenko should not be limited to the endpoint of that 20-day period. Now, the evidence needs to focus on whether on location complied with Chief ALJ Adams' recommended decision, ordering on location to comply with the rules and statutes governing the advertisement of its services. So the focus of the evidence should be on that narrow issue and not anything beyond that. So that's the first part of my ruling on the motion to limit. I will grant the request in the motion to limit to take administrative notice, not judicial notice, but administrative notice pursuant to Commission Rule 1501C of the documents in proceeding number 24F-0236CP. And by the way, Mr. Lysenko, I didn't see that you addressed that in your response. Do you have any objection that you'd like to make, just to clarify on the record, to taking
Yes.
administrative notice?
Yes, I do, Your Honor. And if I may speak up, their administrative chief Lodge made the order to cease and desist until on location compliance with all PUC rules and statutes. The brokerage involving 3 rules, which is definition, operating under somebody else's authority, selling somebody else's services, and finally notifies customers about being a broker. So just being and limit the scope just for notify customers being a broker, it's like if I will state on my website that I'm an attorney, and now I will be able to provide legal advices. So just by stating that I'm and limiting the scope, if on location only notify the customers about being a broker, is not going to comply with the old PUC rules about the brokerage. The brokerage involves 3 portions, and it's last thing that the broker needs to do is notify customers being a broker. So if we're going to limit right now, then I can probably just be an attorney and just notify people that I'm an attorney and start giving legal advices to people because I'm notifying. So it's the less that the broker should do is notify customers being a broker. And that's where my response was common. And if we're going to limit right now, it's not going to be on location will not be in compliance with the order from Chief Administrative Law Judge, because it says all PUC rules about brokerage. So just limiting for notifying customers not gonna comply. On location will not be in compliance with the previous order.
Okay. Thank you for that, Mr. Lysenko. My specific question was whether you object to taking administrative notice of all the documents in proceeding number 24F-0236CP, which was the proceeding in which the recommended decision was entered that you were just referring to. So do you object to me doing that?
No, Your Honor.
Okay. So I'm going to go ahead and do that and grant that request in the motion to limit. And let me just say in support of my ruling that, will be reduced to writing in my recommended decision in this proceeding. My interpretation of the recommended decision, like I already said, is that it focused ultimately narrowly on violation of the rules governing advertisement of services, and specifically on locations, failure to adequately disclose that it had that it was offering transportation brokerage services and did not itself offer the transportation services offered on its website. That's my interpretation of the recommended decision by Chief ALJ Adams. And what he ultimately found and concluded. I recognize that there is some broader language in the recommended decision, as you cited, Mr. Lysenko, but I think really the locus of the recommended decision was narrowly focused on the issue of whether On Location failed to adequately disclose in its advertising on its website that it was a transportation broker. That was the only violation that Chief ALJ Adams found in his recommended decision. And further, I think the complaint in this proceeding only alleged violation of that prohibition or that portion of the recommended decision. In other words, the complaint here basically said narrowly that On Location did not comply with Chief ALJ Adams' order to cease and desist from stating on its website that it was offering transportation services without adequately providing notice that it was merely a transportation broker and did not itself provide the transportation services that it included or advertised on its website. Again, that's my interpretation of the complaint, that it was narrowly focused to that. So as a result, I think there's a notice issue in this proceeding. The complaint obviously is required to provide notice of the violations alleged and the basis therefore. And the complaint here, I believe, really only alleged violation of that, the single narrow finding by Chief ALJ Adams in his recommended decision. That's excuse me, that's the decision that I'm going to make on the motion to limit. And Mr. Lysenko, yeah, I don't know. Do you want to make a further record on this?
Yes, Your Honor, I will be appealing that. With all respect, I will be appealing that decision. The reason why my complaint was strictly that On Location did not comply with the LJA order. Can we please open up without just talking about the decision and the LJA waiting and talking about like in general about violation? Can we just read the order? Just simply read the order. And order, which is part 5, number 3, it says in the order, On Location shall cease and desist from providing and offering to provide services as a common carrier until such time as it has complied with all Colorado statutes and commission rules governing such operations. This is the order. There is 5 parts in the order, including the decision is effective immediately. 5 parts. So that was the order. We don't need to go deeply into the and poke portions of the decisions and just trying to see what's the interpretation of that. There is a specific order, and the order part number 3, that's what it says. With all Colorado statutes and commission rules governing such operations. Why do we need to limit right now only to advertising? Because it's been mainly decision was going around the advertising. It says all, and it includes 3, again, different parts that the broker should do to be treated as a broker and to be classified as a broker. It's not only labeling yourself being a broker. So it says all in the order, and my complaint was about On Location did not comply with that order, and specifically part number 3, where it says all.
So here's my response, Mr. Lysenko. We're not going to go back and forth anymore on this. So the ordering paragraphs in a recommended decision do not repeat and recite everything that comes before it. Obviously, that would be pointless. The paragraph that you just cited in the ordering paragraphs, and it's ordering paragraph number 3, is on page 27 of the recommended decision. So it would be pointless to basically repeat everything that preceded the decision, in the ordering paragraphs. And I would just cite for you ordering paragraph 2, which states the formal complaint filed by Mountain Star LLC doing business as Red Rock Shuttle, Mountain Star in quotes, is granted in part consistent with the discussion above. And as I've already cited, up above on the immediately preceding page 26, Chief L.J. Adams stated in the first paragraph, in the first sentence of paragraph 119, as the offense here is the advertisement appearing on Location's website at the time the complaint was filed, On Location is clearly culpable for the violation of Rule 6016 and 6202. That's ultimately what he found, that was the sole violation, the sole set of facts that he was focusing on for the violations that he found. So I believe that my interpretation of Chief L.J. Adams' recommended decision is accurate. And frankly, you had the opportunity in that previous proceeding to prove that On Location's violations of the commission's rules and relevant statutes was far broader than just the advertisement on its website. You had that opportunity. You didn't do it. You weren't successful in it if you tried. And you're not going to be given a second opportunity now to prove broader violations for historical conduct that were addressed or that you had the opportunity to address in proceeding number 24F-0270CP. So that's my ruling on the motion to limit. And again, you're not going to be limited to just the 20-day window. The end date on the 20-day window is not applicable. You can go beyond that end date that Mr. Jennings identified. But otherwise, the motion to limit is granted consistent with what I previously said. So let's move to the motion to quash. Mr. Valentine, do you want to repeat or summarize the basis for the motion to quash?
I won't repeat, Your Honor. I guess I would just say that in light of your ruling just now, it makes it even less appropriate for Ace and Ramblin to appear. They have no personal knowledge at all of the intentions of the advertising, what's actually on the website, how it's presented. That's all completely beyond their knowledge. I'll stipulate that nothing in their relationship has changed with On Location, but that's not even part of this case anymore. So the motion to quash should be granted.
Okay. Mr. Valentine, are your witnesses here today available to go?
I have Mr. Holland. I regret to inform you that Mr. Davis is in Taipei and I guess got the dates wrong. I think he's tried to appear, but not successfully. So that is unfortunate, and I apologize for that.
And who is Mr. Holland?
Mr. Holland is the representative of Ramblin who will testify here today.
And that means Mr. Davis is Ace Express?
Yes.
Okay. All right. And Mr. Valentine, in your motion, you state that the current subpoenas that are at issue here represent, and I'm quoting here now, the third time that Mr. Lysenko has subpoenaed Ace, and the second for Ramblin to testify about a broker's actions. That's your motion at 2, at page 2. I believe
That
Well,
includes the first case, obviously, Your Honor.
okay, so that's Chief L.J. Adams case,
Yes,
proceeding number 24F-0236-0236CP. Is that
yes,
right? And
yes.
so both were subpoenaed there?
Both gave lengthy testimony in that case.
And at what point did they give their testimony? I understand that there was a hearing to address, I think, jurisdictional issues relatively early in the proceeding. And then there was obviously the final evidentiary hearing
They
on.
gave, that's correct, Judge. They gave lengthy testimony before the jurisdictional question was addressed. And there were numerous exhibits introduced about the relationship between Ace and Ramblin', and On Location. There was lengthy testimony about the operations, how it was charter bus operations, even under the commission's rules, how Ace and Ramblin' basically were operating at the discretion of On Location, which controlled the drop-off points, the route, the pickup points, and so forth. So that transcript is available to the parties as you've just ruled.
Okay. And so was that in the hearing that was narrowly focused on jurisdictional issues? Or
That's
that
correct,
testimony?
Your Honor. That's
Okay.
correct, Your Honor.
All right. And then, so my understanding is before the evidentiary hearing, your clients, Ramblin' Express and Ace Express, they had been named as parties in the complaint in that proceeding, but they were dismissed by Chief L.J. Adams before the evidentiary hearing on the merits took place. Do I have that right?
That's right. They testified under oath about all of the things that they would have testified to in the main hearing if they had not been dismissed.
Okay. So I believe Ace Express was subpoenaed in proceeding number 25F-0178CP. Do I have that right? I'm not
Um,
sure. I'm not sure
yes,
what that proceeding is or who that's pending in front of. Do you know?
that is a proceeding that is pending in front of Judge Rosenberg.
Okay.
And Mr. Davis appeared and answered Mr. Lysenko's questions about its current operations, but not with On Location. It's a different company.
Okay. All right.
And
Um,
basically, the testimony from Mr. Davis in that case is about its relationship with its clients. It mirrored the testimony that it provided in the first On Location case.
and when did that hearing take place? What was the hearing focused on?
The hearing was focused on Mr. Lysenko. Feel free to chime in here because I didn't stay for the whole hearing. Once my witness was excused, I left. But it is a similar case to this one.
So is it your understanding, and Mr. Lysenko will have plenty of opportunity to respond to this, but is it your understanding, Mr. Valentine? I mean, was this the hearing, the evidentiary hearing on the merits, or was there another jurisdictional type
No,
dispute?
this was on the merits, and Ace was subpoenaed as a third party.
And who is the respondent in that proceeding, if you know?
Mr. Lysenko, help me out here.
Okay.
It's Rocky Mountain Shuttles or something like that.
Okay. All right. Um, okay. So anything further, Mr. Valentine?
No, Your Honor.
Okay. Mr. Lysenko, can you can tell me whatever you want in response to the motion to quash. First of all, let me just ask you regarding that proceeding that I was just asking Mr. Valentine about, proceeding number 25F-0178CP. I take it that you're the complainant in that proceeding. Do I have that right?
Yes, Your Honor, and it's not, yes, Your Honor.
And go ahead. I mean, can you just tell me a little bit about it?
Yes, yes.
Who it's against?
First of all, I would like to object on that motion. And in opposition, I would like to say Mr. Valentine cannot testify simply on behalf of their customers. If something changed in the relationship or not, that's not the Mark Valentine should testify. Second thing, all the testimonies on a separate proceeding, I'm not sure how they can be applicable to this proceeding, because every contract, every relationship between different companies are different, and especially that complaint wasn't on a merit. The Rocky Mountain Event Shuttle was actually had the disclaimers about being a private group kind of transportation, not simply just a broker. There was it was slightly different proceeding, except just being a broker. So, and again, testimony about ACE with somebody else's relationship, how they can be applicable to this proceeding, I'm not sure.
Okay. So maybe you just said and I missed it, but who is the respondent in that proceeding 25F-0178CP?
It was DTR Operations LLC doing business as Rocky Mountain Event Shuttles.
Okay. And was the testimony by Ace Express in there? Did it focus on its relationship with the respondent?
Only with the respondent, with Rocky Mountain Event Shuttles.
Okay. So did you allege in the complaint that the relationships between On Location on the one hand and Ace Express and Ramblin' Express on the other hand changed since May 29th, 2025, which was the issuance of Chief ALJ Adams' recommended decision?
No, Your Honor. The only thing, because I didn't feel like it's necessarily, because I was pointing to the order, again, to the order to comply with all Colorado rules and regulations governing that operation. And to comply with that rule, that is necessarily to show that the relationship and show the relationship between these two companies or three companies is actually essential information. I was going from the order by the administrative law judge. I did not go deeply into the decision and just picking and choosing portions of that decision. I was going just by the order. And my complaint was written in regards to the order. And in that order, it was not necessarily to point if the relationship changed or not, because it is necessarily to show that to make sure they complied with the order part 3 with all regulations governing those operations. That's why I did not include that, because I did not go narrow step by step and point every little thing on the decision. I was going by the order.
Okay.
Judge, at the risk of repeating myself.
Well, hold on, Mr. Valentine.
Yeah.
This is Mr. Lysenko's time now. So Mr. Lysenko, is there anything further that you'd like to say in response to the motion to quash? I've read your response. And I have a question or two further about it, but first I'd like to just give you the opportunity to see if you'd like to say anything further in response to the motion.
Yes, Your Honor. I would like to note that PUC is not just a mediator between two parties. PUC is about protecting the public and authorized carriers. So, and the in response to that, to see the picture and to see the way the respondent operates, it's essential to talk to ACE Express and do the direct examination of Ramblin' Express also.
Okay, so let me ask you this, Mr. Lysenko. As I noted, I've read your response. Let me just quote a sentence to you from your response, and it is, ACE and Ramblin' possess unique material knowledge regarding their contractual relationships with On Location, the operational practices employed in providing transportation services, and any changes in those relationships or practices since the issuance of decision number R25-0406. And that's your response to the motion to quash at page 2. So as everybody knows, I've granted the request in the motion to limit to take administrative notice of basically the record, which includes the transcripts in proceeding number 24F-0270CP, which I believe was the proceeding that Chief ALJ Adams presided over. So, and in that proceeding, I mean, it's my understanding, I reviewed quickly the transcripts of the hearings conducted in those proceedings. And I believe that both ACE and Ramblin' provided testimony regarding their contractual relationships with On Location. Do I have that right, Mr. Lysenko?
Right. Prior to the decision, yep.
And that they also provided testimony regarding their operational practices employed in providing transportation services. And I understand that would have been as of the date that they provided the testimony. Do I have that right, Mr. Lysenko?
Yes, Your Honor.
Okay.
Prior
Sorry, I'm interrupted. Go ahead.
Yep. Yes, Your Honor, you're correct. They provided that information on their operations prior to the decision. Yep.
Okay. So obviously at that time, they did not provide testimony regarding the third category that you noted that I read to you in your response, which were changes in those relationships or practices since the issuance of decision number R25-0406. Are you aware of, do you have any evidence of any such changes since the issuance of decision number R25-0406?
And this is the reason why we need direct examination to get the evidence.
Okay, so I mean, it sounds like you don't have any evidence currently, and you want to question them about whether there have been any changes. Do I have that right?
Yes, you're correct, Your Honor.
Okay, and what this is going to be speculative, so I'll just tell you up front, Mr. Lysenko, I completely recognize and understand that, but what kinds of changes in the business dealings with On Location would be relevant to whether On Location is complied with decision number R25-0406?
For example,
Go ahead.
I'm sorry, Your Honor, I'm sorry for interrupting, but for example, if Ace or Ramblin got the common carrier license and the unlocation started reselling their tickets, for example. For example, if somehow in this, after the decision, unlocation actually started providing or selling Ace or Ramblin Express individual tickets without them getting the license, for example, or common carrier authority. And then it would not be an unlocation problem. It would be the Ace and Ramblin Express problem. So, and the unlocation can be dismissed from this case. Because again, I was going off of the order. I was going in the order by the 1, 2, 3, 4, 5 portions of that order. I did not go into the decision and choosing and checking on the little portions of the decisions. I was going by the order. And to comply with that order, it's essential to see whose tickets out there. Does that company has the authority? Did the service provider got the finally authorities, or unlocation got the authority, or what's the relationship, and if there was any changes to that?
Okay, and when you just said that you went by paragraphs 1, 2, 3, 4, 5, you were referencing the ordering paragraphs on pages 27 and 28 of decision number R25-0406. Do I have that right?
Yes, Your Honor. Yes, Your Honor.
Okay. All right. Okay, Mr. Lysenko, do you have anything further in response to the motion to quash?
No, Your Honor. Thank you.
Okay. Mr. Valentine, is there anything further that you'd like to say in light of what Mr. Lysenko argued?
Well, Judge, the complaint is the complaint in this case. It's not against Ace or Ramblin', and their operations aren't at issue. The only thing that's at issue is On Location's advertising. And so changes in the relationship really still aren't relevant. I mean, as Mr. Lysenko just indicated, it seems like what he wants to do is to get into Ace and Ramblin's operations because maybe they're the parties that are really at issue in this case. And that's the information that he wants. But that's not appropriate given the complaint in this case. So
Okay.
the motion to quash should be granted because Ace and Ramblin's testimony is not relevant to this case.
Okay, I understand. Thank you very much for that. So let me tell you what I'm going to do here. But before I do, let me just ask Mr. Lysenko. Mr. Lysenko, if I deny the motion to quash in any way, you've now heard that the witness for Ace Express is not available today. So the question is what you would want to do in light of that. We could continue the hearing to a future date in which everybody is available, or we can go ahead today with your understanding that you're not going to get the testimony of Mr. Davis on behalf of Ace Express. So,
And Mr. Davis is happy to appear, and we apologize for his not being here.
Understood. So let me just tell you what I'm going to do with the motion to quash, okay? And then, Mr. Lysenko, you can answer the question that I just posed after that. So I'm going to grant in part and deny in part the motion to quash. And I will allow you to inquire, Mr. Lysenko, about with those witnesses, about any changes in their company's relationships or practices since the issuance of decision number R25-0406, which was a third category of testimony that you were seeking as identified in your response to the motion to quash at page 2. So that's what I'm going to allow with these witnesses. I'm not going to allow you to go back into testimony that was already obtained in the previous proceeding, number 24F-0270CP. The motion to quash will be granted in part and denied in part, consistent with what I just said. So the question for you, Mr. Lysenko, is what you want to do in light of that. We're all here today with the exception of Ace Express. There is no witness on behalf of Ace Express. So the question is whether you want to go forward today, understanding that you're not going to get the testimony from Ace Express, or whether you want to continue the hearing.
Your Honor, at some point, may I offer a response on behalf of the respondent?
Yes, but let me hear from Mr. Lysenko first.
Thank you, Your Honor. I would like to continue.
Okay. Mr. Jennings.
Thank you, Your Honor. So understanding Your Honor's rulings today regarding what's relevant for the hearing, the witness testimony is going to be subject to my objection about what's relevant and not relevant. And taking notice of the file, Your Honor, there are 3 substantive recommended decisions issued. They do go into great detail regarding the findings of fact about Ace rambling on location. There are the transcripts as well, as you mentioned.
So let me interrupt you for a second. I apologize, Mr. Jennings. You just said 3 substantive recommended decisions, and I'm trying to understand what they are. If they're all in, well, first of all, are they all in proceeding number 24F-0236CP, Chief ALJ Adams proceeding?
Correct, Your Honor. I'm just
Okay.
looking at them right now.
And so let me just clarify for the record that the only time that we issue, I think I have this right, recommended decisions are the final decision in the proceeding. So the previous decisions that you're referencing would have been interim decisions. So I think what you're saying is the 2 interim decisions, substantive interim decisions, I mean, I'm assuming one of them had to do with the jurisdictional issue. I'm not sure what the second interim decision would have been addressing, but then the final recommended decision, those are the 3 that you're referencing in proceeding number 24F-0236CP. Do I have that right?
Correct, Your Honor. I see the I right there on the 2 prior decisions. The recommended decision came out in May, and it incorporated the prior findings and rulings that have been made in those other decisions.
Okay.
And, you know, On Location was ready to proceed with this case earlier. It was continued to today's date. I've heard Mr. Lysenko say 4 or 5 times this morning that he didn't read Chief Judge's recommended decision. He skipped to the ordering paragraph. And that's quite concerning.
Let me just interrupt, Mr. Jennings. I don't think it's fair to say he didn't read the recommended decision. I think what he was saying was, for purposes of generating the complaint in this proceeding, he focused on the ordering paragraphs at the end of the recommended decision. So that's my understanding of what Mr. Lysenko said, not that he didn't read the recommended decision. So go ahead.
Yes. Thank you, Your Honor. I will just say that On Location has closely read and analyzed that decision that goes into great detail about how the prior proceeding ended and the advisements to On Location. We haven't had an opportunity to say this yet, but On Location strongly disagrees with Mr. Lysenko's claims that they are out of compliance. and that there are any ongoing violations. So from our perspective, Your Honor, as the respondent, we did come here today to address the relevant issues. We brought our witness and to continue this hearing again to a different date because one of the witnesses who's not a party to this case did not appear would be prejudicial to on location. And, you know, to the extent that that issue needs to be dealt with, we don't feel like punting the hearing again. We feel like that would be prejudicial to on location at this point because the issues are so narrow, and we can proceed today in light of Your Honor's rulings.
Understood, Mr. Jennings. So your client opposes a continuance is basically the sum and substance of what you just said.
Correct, Your Honor. Just because from the respondent's point of view, we're responding to the complaint for Mr. Lysenko, and we are here today to respond to that complaint.
Understood, Mr. Jennings. And let me ask you, do you agree with my characterization of what Chief ALJ Adams found and concluded in decision number R25-0406?
We do, Your Honor, and that's why, you know, down to the specific citations and the analysis of that recommended decision, that is our contention. And potentially, Your Honor, we could go forward with testimony from on location and Mr. Lysenko. If Your Honor determines that a further hearing needs to be held to hear from the other non-party witness, that could be one way to handle this. But yes, we do agree with sort of the narrow scope and the purpose of today's hearing.
Okay, thank you, Mr. Jennings.
And Judge, to the extent it matters, Mr. Holland is here to testify today.
And Your Honor, one final point. I would like to note that Michael Botti is here on behalf of On Location. And Mr. Lysenko can ask questions to On Location's witness with respect to any changes that have been made after the entry of the decision, whether that concerns advertising or the relationship to Ace and Rambler. So he will have the opportunity to ask On Location's witness that question.
Thank you, Mr. Jennings. Thank you, Mr. Valentine. Mr. Lysenko, anything further that you'd like to say?
Yes, Your Honor. I would like to do the oral motion for leave. This hearing did not start the way the complainant was prepared. So the ruling that was made last minute, that the other motions that being reviewed last minute prejudices the complainant, even without the witnesses, even without the limiting the scope of hearing to portions of the decisions and the orders. So I would like to do the oral motion for leave to review that and better prepare for the hearing. And if we need to explore the options for filing exceptions and appealing the previous rulings. So I would like to do the motion for leave, an oral motion for leave anyway.
Okay, and I take it that in your oral motion, you're requesting a continuance, Mr. Lysenko?
Yep.
Okay. So here's what I'm going to do. I'm going to grant the motion to continue. I've heard all of you on balance. I understand that there's prejudice to everybody involved here today, but on balance, I believe that it makes the most sense, the most efficiency, the most judicial economy, and frankly, the fairness to all the parties for everybody to be present at the same time when all of the evidence is taken. So Mr. Jennings, Mr. Valentine, you suggested that we could basically do what we can today with the hearing and then continue it to allow for testimony from Mr. Davis of Ace Express at a later date when he's available. I frankly think that's the most prejudicial outcome here today to everybody involved, including the commission. I think it makes far better sense to have everybody available on the same date, participating at the same time for efficiency's sake, and then also for fairness to Mr. Jennings' client, who no doubt will have to attend any future continued hearing as well, to be prepared to provide any type of rebuttal testimony. So that's what I'm going to do. I'm going to grant the oral motion to continue the hearing, and I'm going to direct you, Mr. Lysenko, to work with Mr. Jennings and Mr. Valentine to find a date that works for everybody involved. And towards that end, I would direct you to consult the commission's online calendar to see when my available dates are. And you can always email me, anybody can, but copy the attorneys, all of the attorneys. If you send me an email to inquire about available dates, I don't want any substantive emails addressing any issues in the proceeding. The only purpose of any email to me would be to address my availability for the continued hearing. Mr. Lysenko, do you have any questions for me regarding what I just said?
You're on mute.
I was muted. No, Your Honor. Thank you.
Okay. Mr. Jennings, do you have any questions?
No, Your Honor. Thank you.
Okay. Mr. Valentine, do you have any questions?
No, Your Honor.
Does anybody have anything else you'd like me to address here today? Okay, nobody's jumping up. So what I'm going to do is I'm going to continue this hearing to a future date that will be determined after I hear back from the parties regarding availability of everybody involved. So with that, let me thank everybody and wish you a good day and a good Thanksgiving. And I'll see you soon. We're adjourned for today.
Thank you. Have a good day.
Thank you.